Muy buenos días, muy buenas tardes.
Welcome everyone. Good morning, good afternoon.
Es un placer.
It is a pleasure for us to have you here. I'm sorry, I was in a different channel, so I'm sorry about that. As I said, good morning, good afternoon, good evening. On behalf of the Constitutional Studies Center of the Supreme Court of Justice of Mexico and the Law School of Leiden University, we want to welcome you to this fifth session of our online conference cycle on access to justice for children in practice, with this particular focus on the use and the potential of the third optional protocol on the Commission of the Rights of Children. This session, today's fifth session, allows us to share with a couple of colleagues, friends, and activists in children's rights. We are going to be introducing Ann Skelton and Conte later, but we want to focus today's session, as you were able to see on the flyer of the session. Our particular focus is on the procedural remedies that come as a result of these third optional protocol as a tool for giving access to justice for children and discussing the nature, effectiveness, in order to see what happens with the use of these remedies when it comes to this protocol. So now I want to give the floor to Ton Liefaard from Leiden University.
Thank you so much, Nico, for starting this session. A very exciting moment. Again, I would argue, fifth session in this webinar series focused on OP3. Greetings from Leiden University in the Netherlands. From my side, I can say good afternoon, but I know that you are from different parts of the world. So good day to everyone, and thank you for joining us. Maybe you join us again, so welcome back. And maybe for some, it's the first time. But today will be a very exciting webinar, I'm no doubt about it. And we would really like to explore not only the meaning of having an access point for children internationally, an access point giving them access to justice, meaning that they can actually also really challenge the way their rights are being protected by states. But we want to go beyond that, and we want to explore ultimately what it delivers, not only for the children in an individual case, but also what it could deliver also for reform. Sustainable reform, social reform, a reform that is really informed by and driven by children's rights. So greetings from Leiden University, and also greetings to our colleagues, our expert speakers, and in particular to the Center for Constitutional Studies. It's wonderful to team up again. It is my great pleasure also to go straight into the program by introducing our first expert speaker, and that is Professor Ann Skelton. Ann Skelton is currently serving in her second term as a member of the United Nations Committee on the Rights of the Child. And in that capacity, she is also directly involved in the specific working group responsible for the third optional protocol under the convention. In fact, she's chairing that working group. But Ann Skelton is a professor of law, and she holds the UNESCO chair in education law at the University of Pretoria. And she also holds the rotating chair enforcement of children's rights at Leiden University. She's also a visiting professor at the University of Strathclyde, and she also teaches in the Masters on International Human Rights Law at the University of Oxford. She is an internationally renowned researcher and teacher, and has published widely on children's rights and the many different fields children's rights affect. But she has also a keen interest in education law, restorative justice, and of course also strategic litigation. Because in relation to that, it's important to mention that she has led the well-known Center for Child Law for a long period of time of her career. And under her leadership, the Center for Child Law managed to bring very important cases around children's rights matters to the South African Constitutional Court and to various other South African courts of law. And that has resulted in important jurisprudence that was not only, or is not only, meaningful to children in South Africa, but has served as examples also for courts and for litigation in other countries and across the world, really. So it's a wonderful opportunity, I think, to hear from her, not only from the from her perspective as a member of the Committee on the Rights of the Child, but also because of her vast experience in strategic litigation for children's rights, to hear from her what she thinks about the potential of having this access to justice mechanism at the international level. So thank you very much, Anne, for joining us today, and the floor is yours.
Well, thank you very much, Ton, for that introduction, and thank you, Nicolás, for hosting today's meeting. I'm very excited to be able to go with you through some of the jurisprudence that shows a development in remedies through the optional protocol work. And in order to do that, I want to share my screen. So I will just do that so that I have my PowerPoint presentation in front of me. I think we need to start by just discussing what do we mean by remedies. Today's workshop is called Creating Change Through Remedy. But before we even get into creating change through remedy, we have to think about what is remedy, why is it important when we're talking about children's rights, and where do we find it in the international legal framework. So it's interesting that the convention itself does not contain the word remedy and doesn't give us specific guidance. But fortunately, general comment number 5, which develops the normative framing of Article 4 of the convention, does have something to say about this in paragraph 24. The committee there explained that for rights to have meaning, effective remedies must be available for violations. So in other words, and any lawyer knows this really, that where there is a right, there must be a remedy. Because my legal system background comes from a Roman Dutch law, I'm familiar with the Latin maxim on this, which many of you might be as well. Ubi ius, ibi remedium. And that means that wherever we're thinking there might be a rights violation, then there must be a remedy for that. There must be a way of putting that right, because the notion of justice requires there to be a solution to a rights violation. So general comment number 5 goes on to say that this requirement is implicit in the convention. And I would actually say that the optional protocol on a communications procedure completes that implicit presence of remedy, because obviously by setting up a communications procedure and allowing for remedies within that communications procedure, it's quite clear then that the Convention on the Rights of the Child is a pathway towards remedies. And the general comment goes on to explain as well that it is also present in other major international human rights treaties. And so what this means is that states need to pay attention to ensuring that there are effective child-sensitive procedures available to children at the ground level. So very often when we talk about the optional protocol on a communications procedure, and I'm going to call it Opic from now on, when we talk about Opic, we tend to think at the international level. But one of the big advantages of Opic is that it must cause states to build pathways of access to justice from the ground. And that is a very important part of what states need to do when considering ratification, and when they have ratified the optional protocol, they also need to think about what does that mean for them then? They need to be making sure that children have access to justice, and that if they do bring complaints, that they can get those complaints heard and dealt with, and that at the end of that process, there should be an effective remedy, a solution that actually makes a difference and puts right what had gone wrong as far as that is possible. And this child-friendly approach to access to justice requires allowing for children to self-advocate, to be their own human rights defenders. They need to have access to independent bodies like human rights commissions or children's commissions that can take up issues on their behalf. And sometimes it might even need them to have legal assistance in order to take matters to court. Now, of course, we don't want children to have to take matters to court every time there's a problem. We want them to be able to get those problems solved on the ground as easily and quickly as possible at the first level of decision making. And it's only really when one doesn't get access to justice, or when one can't obtain the remedy at the national level, that you would then go on to trying to seek justice at the international level. And General Comment 5 is clear that where rights have been found to have been breached, then there should be appropriate reparation, including compensation and, where needed, measures to promote physical and psychological recovery, rehabilitation and reintegration. And that's required by Article 39. General Comment number 5 goes on to also talk about the fact that the justiciability of rights is not limited to civil and political rights, but also includes economic, social, and cultural rights. And therefore, it is necessary for domestic systems to ensure that these entitlements are set out and are enforceable, and that it is possible to get remedies for compliance. Of course, remedies for socioeconomic rights are always a little bit more complex because these rights tend to cost money. They require investments by the state, not just to stop the state doing things that they shouldn't do or to correct a law. It actually usually means, you know, you've got to put money into improving your education system or your health system. And in order to do that, therefore, the remedies have to be framed in such a way that they can give the state a little bit of time to be able to do that in accordance with progressive realization, but at the same time not to allow too much space there, because otherwise we may find that socioeconomic rights fulfillment never happens. So in a sense, the space that is needed and the framing of remedies that is needed is slightly different for socioeconomic rights. But what is important, and what General Comment number 5 is stressing, is that we need remedies for both. So it's no good saying, well, we can't do much about, you know, these things that cost a lot of money. No, indeed, we do need to have remedies that put states on terms to delivering on their socioeconomic rights as well. It's also useful to look at the International Covenant on Civil and Political Rights, because Article 2.3 provides that each state party to that covenant must ensure that any person whose rights or freedoms have been violated have access to an effective remedy, and also that any person claiming such remedy will be able to go to the competent judicial, administrative, legislative authorities or other authorities, and to ensure that competent authorities shall enforce such remedies. So sometimes we actually see, and we have had cases like this coming through Opic, where the court in the country at the state level did provide a remedy, but then the state doesn't follow through and fulfill that remedy. I can think in particular of a case, and it was a case I'm afraid I can't quite remember now which country it was, but it was in South America, where the state, where the courts had provided that a father should have contact with his children. But the state authorities never fulfilled that. They simply kept on delaying and delaying and delaying. And in the end, that failure to enforce the remedy at the national level became the kind of problem that could be brought to the Committee on the Rights of the Child, which did find a violation in that case. Now, I want to look at some of the remedies that the committee has handed down over a period of time. And I can say before I go on to that next slide that remedies, of course, always come at the end of the process. So when you're looking at the views, there's a lot to read through. But when one finally gets to the end, this is where we see what does the committee ask the state to do to put things right. And remedies must contain, or not must, but can contain both remedies for the individual whose rights were violated, because this is an individual communications procedure, but can also include measures that would prevent this from happening again to any child. So in that way, although this is an individual communications procedure in the sense that it has to be either an individual child or a group of children who are the victims of a rights violation, they bring a case. But when it comes to the remedy, we can actually go beyond that individual, that group of individuals. And so in a sense, although the communications procedure itself is individual, the remedies part of it is collective. Or it has a collective effect. It can affect more people than just the particular child or group of children concerned. And so it's quite, I think, an opportunity then for real change and systemic shifts to happen through these remedies. And so that brings us back to the title of today's seminar, which is about bringing change through remedies. And that tends to focus more on the collective part of the remedy, the systemic part of the remedy. So I want to take you through a series of remedies looking at the committee's jurisprudence. And I will point out to you, what the committee was thinking in terms of individual remedies and what they were doing in terms of systemic remedies. And I also want to show you through these cases that I'm going to touch on how the remedies have been developing over time. So, this is a relatively new communications procedure. The committee may have been a little, timid, to say, exploratory at the beginning, not quite sure how to frame remedies, how far to go. But what I think one can see is an increasing boldness in remedy and an increasing awareness of the power of remedy for systemic change. But I think not only systemic change, even the individual remedies are getting stronger, I think, as we go along. So let's have a look at some of those cases. So many of the early remedies of the committee were very general in nature. NBF versus Spain was the case, well, in fact, one of many cases that the committee received against Spain on age determination in the context of migration, where children were presenting to authorities that they were below the age of 18. The authorities had doubts about that and were relying on a X-ray method, a medical method, and not taking into consideration the margin of error that could occur from that, and not being sufficiently holistic in the way that they were assessing age. And so in NBF versus Spain, the applicant was saying that he was under 18. The authorities were pretty sure that he was over 18. And there was no independent evidence really in this case. And in fact, this was an interesting view, because here the committee split and there was some dissents, because some of the committee members actually also felt that, look, there's no evidence here that this person is below the age of 18. And if he isn't below the age of 18, then he doesn't come in under our communications procedure. But the majority said, but that's that's the very question that he's asking us to address. If we don't give him the benefit of the doubt, this question never gets answered. I mean, that can't be right. And so the committee, the majority of the committee found that we had to give him the benefit of the doubt, and indeed Spain should have given him the benefit of the doubt, and that this would be an important aspect of assessment of age going forward. Perhaps because the particular applicant in this case had not ever proven that he was below the age of 18, unlike many of the other cases where we actually did have proof, found later that the child was 18, the committee in this case decided not to provide an individual remedy for this individual, although did find a rights violation. And the committee went on to provide a systemic remedy, or a remedy to prevent such things from happening again in the future, but it was rather broad. It said, all procedures for determining age of possible unaccompanied children are carried out in a manner consistent with the convention and assigned a legal or other representative free of charge. There were a few more words than that in the remedy, but you get the idea. It was kind of generic, not very clear, just a kind of generalized, you've got to do better, have better procedures, provide legal representation free of charge in order to prevent this. The next case where we see a little bit more in both the individual and the systemic remedy was DD versus Spain. This was about summary deportation or pushbacks in the context of migration. And here again, in this instance, the children had been treated quite the child, sorry, had been treated quite roughly by the authorities, detained with adults and so on. So here the committee decided that there was a rights violation and provided and asked that the individual be provided with adequate reparation, including financial compensation. So whilst that wasn't provided in MBF versus Spain, here we see the committee tentatively moving into the space of financial compensation, which, by the way, the other treaty bodies seem to be much more comfortable at using, but the Committee on the Rights of the Child is more tentative about. Then, from a systemic point of view, the committee got quite technical and precise in DD versus Spain. Because we had quite a lot of information in this case about what was wrong with the law and how it needed to be fixed, and because we had a bit of an indication that the state was kind of willing and already on the way, perhaps, towards doing this, it was easier to give very precise direction. So the state party is under an obligation to prevent similar violations in the future, in particular by revising Organic Act number 4, 2015, and revising the 10th additional provision on the special regime in Ceuta and Melilla, which would authorize its practice of indiscriminate automatic deportations at the border. So in other words, stop allowing automatic deportations, change the law, and these are the specific laws and provisions that we want you to look at. So really quite a precise remedy here, but enabled by the fact that it was we had a lot of information in front of us to be able to be so precise. Sometimes that's not the case. And we also saw in MT versus Spain and RK versus Spain. Now, these were more age determination cases. And by this time, the committee had decided on its general approach in these cases. And so these cases tended to focus more on remedy because the violations part was pretty much already decided. So now, how could we advance a little? And depending on the situation, we talked again about individual remedies involving effective reparation. And here's something new, including an opportunity to regularize administrative status. So give this young person a chance to sort out their immigration status is really what that means. Systemically, again, we see more detail now on age determination. So although the findings and the violations are much the same, we see a development of the remedy on age determination. It says that the state must prevent similar violations through having a proper age determination procedure. Documents must be taken into consideration. If they are issued or authenticated by an authority or embassy, they must be accepted as genuine. So in this particular case, remember in NBF versus Spain, the boy there didn't have any documentation. But in this case, there was documentation that had been put forward by the children in these cases, and it was rejected even though it had come from the embassy of the child's country of origin. And the reason given by the state party for ignoring that document was that it wasn't biometric, it didn't contain biometric data, and it might be a fake, we don't know whether it's genuine and so on. And the committee said, no, if you get documents that are issued or authenticated by the relevant authority or embassy, then you must accept it as genuine. Until something else is put before you that disproves that, you must accept it as genuine. So that was actually part of the remedy, advising them that going forward, they needed to do this. Not just, you know, that they had done wrong in this case and that they should have done that, but that in all future cases, they should do this. Also, it reinforced the fact that each child should be assigned a qualified legal representative or other representative without delay and free of charge, and that private lawyers should be recognized and be allowed to assist in the cases, because in the facts of this case, the lawyers had been kind of kept out of the system, were not able to accompany the child into some of the age determination procedures and so on. And that in addition to that, the child should be assigned a legal guardian. The remedy also went on to ask Spain to develop effective and accessible redress mechanisms at the national level that would allow for the review of decrees of majority. Because what has been a problem on the ground was that once a court had made a determination, or an administrative authority had made a determination of age, there was no way that one could go back at the national level to fix that problem. And so rather than having them must come all the way to the Committee on the Rights of the Child every time, the remedy attempts to build a mechanism here at the national level to address that problem. And then D, provide training to immigration officers, police, prosecutors, judges, other professionals on the rights of migrant children, and in particular, General Comments 6, 22, and 23, which deal with children in situations of migration, broadly speaking. So therefore, you can see here, this remedy quite detailed, both the individual and the systemic remedies, providing clear direction to the state on what needed to be done. Another important development was the case of RYS versus Spain. So we've seen a lot of these age determination cases, and many of them are very similar. But this one was different because it concerned a girl. And when she came through the border, she was subjected to an examination of her genitalia. She had been sexually abused previously, which she disclosed. But that was not the reason for this examination. The reason for this examination, believe it or not, was age determination. That was so shocking that the committee was very, very strong in its wording about the violations, and this case also added to the remedies of the previous age determinations case. In this case of individual remedy, the committee called for reparation, adequate compensation, specialized counseling, and verification of birth date on documents, because what had happened was she had actually altered her own document in order to access something. She had changed her own document, and then they had said they wouldn't change her document back to the correct age. And so she needed to have a proper verification of her documents and kind of get that back. And the committee actually found that changing ages and refusing to reflect correct ages is a violation of the right to identity, which is quite an interesting development. I think this was not the first case that did that. There have been some others that had looked at that issue as well. And then also in remedy, with regard to systemic remedies, the training remedy that we already had in the earlier cases, we added to that and said how important it was to integrate a gender perspective into that training where migrant girls were concerned, so that anyone dealing with migrant girls would have the sensitivity going forward so that this kind of thing wouldn't happen again. And to ensure that unaccompanied minors seeking asylum who are victims of violence, any form of violence, should receive qualified psychosocial counseling. So not only that she should, which was certainly also part of what we asked, but also that any other child in her kind of situation should. So can you see how those remedies are becoming more generalized and more accessible for other children in the future? The latest education case that the committee dealt with that has an interesting remedy is AEA versus Spain. You can see that Spain is very popular with Opic. And I always like to say, this is not because Spain is particularly the worst child rights country. It is because they have lawyers who are very aware of using this mechanism. And that is why we see all of these cases against Spain. So any of you who are lawyers can look at this as a good example of activism on the part of organizations and lawyers who are using these remedies. So this particular case was about a child living in the enclave of Melilla who was not a Spanish citizen, he's Moroccan, but he's living in Melilla and therefore he is entitled under international law to receive education, but he wasn't able to get education and he kept on trying and used various remedies, but nothing was working for him and there was a tremendous delay so that he was losing, he was losing out on education. And so for him, the individual remedy was that he should be immediately enrolled in school, provided effective reparation, including adequate compensation, as well as the state must take proactive steps to help him catch up at school because they had caused a delay that had effectively meant that he'd fallen behind in his schooling. The systemic remedy was that the authorities must take effective and expeditious steps to confirm a child's resident status, because this was the problem. He had resident status, but the state was refusing to recognize certain things and were not providing pathways for that to be determined. So this said, you've got to provide those effective and expeditious possibilities to confirm residence. If it is confirmed, then you must enroll the child immediately. You don't drag it out. The state must ensure that where there is a dispute, then there must be an effective and accessible remedy. And it must be known by the child and the parents so that they know where to go in order to deal with any disputes. And in relation to all of this, it was said that there should be specialized training for judges and administrative personnel. Now I'm coming to the very last case that I want to talk to you about in terms of remedy, and it's hot off the press. This is, in fact, a case which the committee issued its decision on the 24th of February, and it has to do with a finding by the committee that France violated the rights of French children detained in Syria by failing to repatriate them. These are the children of foreign fighters that are stuck in the camps in northeast Syria. And this case came before the committee. We decided on admissibility some time back. You probably touched on that in one of your earlier seminars, but now this was the decision on the merits. And I'm going to jump in pretty much immediately to the remedy. So the majority of the committee found a violation of the rights in terms of Article 6.1, 37A, and 3. Let's look at the remedies then. Detailed remedies, and really rather important. And by the way, this is a big reveal because at the moment, the only official version of this case is in French, but I'm presenting to you from an unofficial English translation. the state party is under an obligation to provide the authors and the child victims with effective reparation for the violations suffered. It is also under an obligation to prevent similar violations from occurring in the future. In this regard, the committee recommends that the state party A provide an official response to each request for repatriation submitted by the authors on behalf of the child victims as a matter of urgency. This was because although the relatives of the children had been sending requests, they had not been receiving responses. B, ensure that all procedures for the examination of such requests and the implementation of any decisions are in accordance with the convention, including inasmuch as they take into account the best interests of the child as a primary consideration and the importance of preventing further violations of the rights of the child. C, take urgent positive measures acting in good faith to effect the repatriation of the child victims. That's quite a big one, because basically what it is saying to France is, you must go and take all the efforts that you can to effect the repatriation of the child victims. D, to support each repatriated or resettled child's reintegration and resettlement. And E, in the interim, take additional measures to mitigate the risks to life, survival, and development of the child victims while they remain in northeast Syria. So I think you'll agree that this is quite a comprehensive remedy that deals with both the individual claimants, but also looks somewhat systemically at the system, because it could be that those procedures for considering repatriation can be used for all children, not just the ones that are included in this particular case. I don't know how much time I have. Am I running out of time?
We still have a few more minutes, Anne.
Okay.
Yeah.
So the only thing that I really wanted to now is to point out that in every case, the committee has a standard clause at the end of its remedy that requires the state to report back within 180 days to say what it has done to give effect to the committee's views. So in a sense, every single remedy is a supervisory order. If you were to compare it to what a supervisory order would look like at the domestic level, this would actually be quite a far-reaching thing to say at the domestic level. Come back and report to the court on what you have done. Generally speaking, courts are reluctant to do that because it goes into the realm of the executive. But it's standard in the decisions of the committee to ask that they should come back and report. And so this is really the beginnings of what we call the follow-up procedure. We want to know what state's done to carry out the remedy, and then we can keep following up to see how that's gone. It's also quite interesting to note that it's a standard clause that this should be published and disseminated, that the findings and the should be made public and should be widely disseminated. Now, I wanted to just draw your attention that on the website of the Committee on the Rights of the Child, in the part that deals with the communications procedure. Oh, and by the way, we've got a brand new, nice looking website. Please go and visit the website of the Committee on the Rights of the Child. It looks completely different. I used to say, you'll find this in the bottom left-hand corner. Now, I don't know where you will find it, but have a look for communications, click there, and then you'll work your way through and look for follow-up. So under follow-up, you will find a table that sets out the follow-up that the committee is doing in terms of individual communications. And it uses a set of criteria to assess how the states are doing in their cases. An assessment criteria ranging from A to D. A is measures that have been taken are satisfactory or largely satisfactory, going all the way down to D, which is no cooperation. So we see that the committee, in terms of NBF versus Spain, has been tracking and following up for a long time, and is the last time they made a statement on this, they said state parties' compliance will continue to be assessed, and we're maintaining the follow-up dialogue. But there does come a time when, you know, this goes on too long, and eventually the committee will then say this is unsatisfactory. Luckily, though, we can also point to some good examples. So CE versus Belgium, where a child taken in under kafala had to be taken to Belgium from Morocco, and the decision had to be reviewed, etc., etc. That was done to the satisfaction of the committee rather quickly after the decision was made known. And I'm going to leave us with the question that I'm hoping Alex Conte will begin to answer, which is, how much change have the remedies brought about? Now, sitting at the committee, measurement of that is rather difficult. We do the follow-up, but it is rather distant, and it's not really very easy for us to get to see that. I think that there is some evidence that systemic measures can make a difference and are making a difference. We do see some satisfactory outcomes. I think that the follow-up on individual remedies, though, is rather weak. You know, the African Committee of Experts actually sometimes carries out visits to the country to see how well they're doing on following up, but our committee doesn't really have the capacity to do that as it currently stands. So it's this kind of, you know, long-term writing and asking. Of course, we do ask the authors' lawyers as well. We don't rely only on what the states tells us. But I don't think it's a particularly strong follow-up. But, you know, this could be supplemented by organizations that are interested in doing follow-up work. And that's why I think that this is an area where there is room for further study and work. And I invite you, any of you who are interested in it, to participate in such work. Thank you very much for listening, and I will now stop sharing the document.
Thank you very much, Anne, for your detailed presentation. And despite there are challenges, I dare to say that I'm quite optimistic when it comes to having a comprehensive and structural response for the use of the OP3. I guess that this opens up some questions about not just how we can use these remedies for considering these structural dimensions or systemic dimensions, but also your final question, how can we really accompany this process developed by the committee and for specific litigators that work in these cases with a reflection on the real effectiveness on these decisions, as it has happened in other jurisdictions. I am thinking about Latin America and some efforts to measure the effectiveness, and I guess there's a nice challenge there that we can take. Thank you for that. Now, for me, it is a pleasure to present our next speaker, Alex Conte, the Executive Director of Child Rights Connect, which is the largest global network made up by NGOs and regional, international, national associations that work for the promotion and the potential of the rights of girls and boys. He has more than 20 years of experience, practical experience at all levels of human rights. He has worked as a criminal lawyer locally, but also with different national and international, intergovernmental and non-governmental organizations, and also as an academic professor of international law and human rights. Besides being an executive director, he also works in the Geneva Academy on International Human Rights. It is a pleasure to have you with us, Alex. Welcome.
Thank you, Nicolás. Thank you, Don, and thank you to Leiden Children's Rights Observatory and the Center for Constitutional Studies of the Supreme Court of Mexico. This is a great pleasure for me to be part of this webinar series on Opic. For us at Child Rights Connect, this is a key instrument to achieving social change, and I want to go through some of the reasons why we take that approach. I want to start by explaining some of the characteristics of Opic that make it an important instrument to consider, and then also highlight that while the use of Opic is important in pushing for positive change in children's lives, we need to think of it as part of an overall package in order to generate lasting social change. Should be conceived of as part of a broader strategy that involves the possible use of multiple mechanisms and the engagement of a diversity of stakeholders. So if I can start with the Opic first and consider this question: how is Opic relevant for children in effecting change? And the answer lies in the fact that Opic, as you've probably considered in the past seminars, is a unique mechanism in being able to address child rights violations. First of all, it allows children to bring complaints concerning violations of the full range of their rights, contained both in the UN Convention on the Rights of the Child as well as its first two optional protocols. So many of the rights that are contained in those instruments are unique for children. The right to be heard, the right not to be separated from parents. You do not find those in other instruments. So using the Opic allows children to allege violations of specific and detailed rights that in principle wouldn't be possible through any other international communications procedure. The second is to recognize that Opic, or recourse to Opic, means that it engages a group of child rights experts, the Committee on the Rights of the Child, to hear and review children's claims, interpret children's rights according to the general principles of the Convention. And according to Opic, in fulfilling the functions conferred on it by the instrument, the committee is guided by the best interests of the child and also regard for rights and views of the child. So here are express requirements for due weight to be given to the views of the child in accordance with the age and maturity of the child, which we don't see specifically addressed in other redress mechanisms. The Opic also contains other child-specific procedures which are centered around making the process accessible to children and their representative. This is also absent in other mechanisms. So that is an important starting point, I think, in terms of thinking of social change that is driven by children and how and why Opic is particularly relevant for children. Then in terms of looking at systemic remedies, I wanted to look at systemic remedies in the context of individual communications, complaints, and also in the context of the inquiry procedure. Ann Skelton has addressed in a lot of detail the way in which individual communications have addressed not only individual remedies for the author of a communication, the complainant in a communication, but also looking at the systemic remedies that are required to prevent, to generate change that prevents similar violations. I was going to trace through the same package of cases that Professor Skelton has regarding age determination. So I won't go through these in detail, but I think an observation to make is that through that expanded development and more specific approach of the committee on the types of remedies that should be seen, as was outlined by Anne, what we see is a multifaceted approach to the question of remedies, which is completely appropriate. So It looks at procedures that are set out in the law. It looks at what documents should be considered, whether by a young person or whether by relevant state authorities. It considers the type of assistance that should be provided to a child in the age determination process, whether it be qualified legal representation, a competent guardian. It thinks about, well, if those procedures fail in the first place, what then? And therefore the remedies package that the committee has considered looks at effective and accessible redress mechanisms that allow unaccompanied migrants to apply for review of any decrees. And then it looks at the other side of the equation by considering who is administering this process. And that takes into account the question of training, the integration of a gender perspective and training, the fact that authorities that might be involved in any medical or quasi-medical examination should never include genital examinations. And from the victim's perspective, also considering the often missed out element of remedies and reparation, which is the element of psychosocial counselling. So I think it's to be applauded the way that the committee has perhaps taken a shy approach in the first years, but in a relatively quick period of time, given that Opic is a relatively new instrument, it's only 10 years old, almost 10 years old, has really taken a full and comprehensive approach to the question of remedies, not just for the victim, but from the perspective of finding ways that can achieve lasting change so as to avoid similar violations in the future. But then I want to complement those observations by thinking about the fact that a recommendation which includes systemic remedies is useless if it is not implemented at the national level. And that's the very motivation for the Committee on the Rights of the Child asking the state to report back on measures that are taken to implement a decision. One of the points that was made by Anne in her presentation. And we see that level of implementation in many of the cases in Spain. So this is another positive reflection that we can look at from the perspective of Opic, that not only have we had a large number of cases in Spain that have been generated by a good level of awareness and competence of legal and other representatives, but also an openness of the state to improving the laws. So if we think about RYS and Spain, which was in which the committee said that genital examinations as a method of age determination should never be applied. In April 2021, Spain adopted a law to protect children and adolescents from violence in Spain. And this law explicitly prohibits genital examinations in any determination procedures. So we see that there is a legislative incorporation and implementation of that decision by the committee. Professor Skelton also referred to the case of AEA and Spain, where we saw a Moroccan boy who was not allowed to enroll in school. And what's interesting about that case is that many other children of Moroccan origin were living in the cities of Melilla and Quetta with an effective residence there, but without an official residence permit. But following the committee's decision in AENA in Spain, the Spanish Ministry of Education just last month adopted a resolution whereby school registration cannot be tied to a residence or visa permit. Instead, it can only be tied to an effective residence by any valid means of proof. So that case has been key to ensure the schooling of hundreds of children in the cities of Ceuta and Melilla in Spain. An important impact in social change. Another element about the Opic individual communications procedure that I want to reflect on is that the committee takes a proactive and informal approach to the communications procedure. Opic creates new spaces, new opportunities for cooperation and informal dialogue between the state and between the committee itself. So this refers to the reporting procedure where states report to the committee every 5 years in a very formal and structured process, but there is now a renewed dialogue and cooperation thanks to the Opic, which at each CRC session, at each session of the committee members meet and follow up with states on their progress to implement the recommendations made by the committee. And the committee publishes states' progress on its follow-up report to individual communications. And this increased informal dialogue has also allowed for several situations that have been brought before the committee under the individual complaints procedure to be quickly resolved. We've seen situations where, as a result of this informal dialogue, petitioners have asked for their cases to be discontinued. So we see, for example, in August 2020, that the UN Committee on the Rights of the Child welcomed Argentina's suspension of deportation of a mother of 3, resulting in the discontinuation of that case. In April 2020, similarly, the Danish asylum for a Syrian mother of 6 was provided and deportation orders were suspended as a result of the informal dialogue with the committee. So that's just to complement some of the matters that were raised in the context of the individual communications procedure. Let me also address the question of social change through the inquiry procedure, because Opic is often thought of in the context of individual communications, as is the case with many other optional protocols. But Opic also has a second mechanism, under which children can bring complaints under an inquiry procedure. And here, the committee can decide to conduct an inquiry where it receives reliable information that indicates a grave or a systematic violation within one of the state's parties to the Opic. The inquiry is different for many reasons. One of the first things is that it involves a much higher threshold. It's not an individual claiming violation of her or his rights, but it's about grave or systematic violations within the territory of a party to Opic. So it's got a higher threshold, but on the flip side, it doesn't include the admissibility requirements of an individual complaint. So there's no need to identify an individual direct victim. It can simply be the children of a country or the children of a city or region. Secondly, there is no need to exhaust domestic remedies, which is one of the main admissibility challenges for individual communications. So while there is a high threshold, actually there are some major benefits to being able to move on the inquiry procedure mechanism. Also different from individual communications, the committee can visit the country concerned. That is with the state's consent, but one of the beautiful things about that is that it really does involve an actual dialogue and a broader dialogue than between an individual victim and the state and the committee, because it provides the committee with an opportunity to meet and to interview firsthand with different stakeholders, with institutions, with victims on the ground. And that level of broader engagement is very relevant to societal change. It's relevant because of the implications that an inquiry report can give, but it's also relevant from the very perspective of this dialogue. It enhances society's ownership and society's empowerment on the issue at hand. Obviously, because the inquiry is limited to grave or systematic violations, it's highly relevant to structural issues. And structural issues, therefore, we're often talking about wider change, systemic societal change. And in this regard, the committee has defined what is grave, what is systematic. Grave is a violation that is likely to produce substantial harm to victims. So a determination regarding the gravity of violations must be taken into account. It must take into account the scale, the prevalence, the nature, and the impact of the violations found. And the term systemic refers to the organized nature of the acts. It means that it must be the probability of these types of violations must not be a random occurrence. It must be through the systemic process that we have. And so what we have at the end of this inquiry is a report that's published by the committee where it can develop standards. And this is another unique element of the inquiry process, because in that inquiry report, effectively what we see is the development of standards that are quite similar in a way to a general comment. Standards on a specific issue with specific recommendations to a state that require the state to take measures to prevent similar violations from occurring. Something we need to acknowledge in terms of the inquiry procedure is that it is a completely confidential one. So the number of inquiries that the committee is currently conducting, assuming that they're conducting any at all, is not in the public domain. What we know is that one inquiry has been concluded, and that was an inquiry by children in alternative care in Chile. The inquiry was conducted in 2018 after several cases of children's deaths in residential centres in Chile were brought to the attention of the committee. And in its inquiry report, the committee found grave and systematic violations of more than 15 articles of the convention. 15 violations that took place over a period of more than 40 years due to unaddressed structural issues. More specifically, it found that there was a lack of a comprehensive child protection law and a lack of accompanying policies with a rights perspective. And the committee found that the state was failing to supervise residential centres, which were a mix of both public and private residential centres. And if we look at that report, what we can see is that the inquiry, the process of dialogue, as well as the recommendations of the report, had a very strong impact in Chile. The state took ownership of the recommendations of the committee. It widely disseminated them. It cooperated with the committee throughout the inquiry process, and at least initially took very concrete measures to implement the recommendations. Some residential centres were closed, Some systemic recommendations were adopted, such as the adoption of concrete child legislation that had a child rights focus, the National Pact for Children, and the creation and appointment of a first children's ombuds person. Now, still, there are continuing measures to be taken, as there always are, but I think it's very telling that both the process and the immediate response to that report from 2018 have been very positive. So that's looking at Opic in terms of the types of remedies and the impact that they can make. Next, what I want to briefly consider before opening up for a Q&A is that we need to think about societal change beyond just Opic itself, but think about generating change as part of a broader strategy. As we've seen from both the individual communications and the inquiry process, Opic can contribute very positively to generate systemic changes. And despite its relative youth, we're already seeing examples of concrete changes. But we need to acknowledge that the changes that we've referred to haven't been possible only because of Opic. We need to remember that a decision under Opic is, as for any decision of this kind, a first step only. A first step that requires implementation, and to achieve implementation, it requires action by a diversity of actors, not just the state, not just the committee. That's if we want to achieve broad and lasting change. So if I can reflect on some of the cases that we've talked about, the Spanish case brought to the committee regarding enrollment of children in school, what's very interesting to note is that at the same time, children in Melilla were actively engaged in a campaign at the national level to raise awareness of their situation. Also, civil society at the national level was involved in picking up the issue after the committee made its decision, and their national advocacy used the committee's decision so as to maintain pressure on Spanish authorities and to facilitate the results that we have. So it's often, as in any case where we're trying to change the cause and effect of social change, when we're trying to trace this, is it because an individual brought a case? Is it because the committee made this decision? Is it because an NGO lobbied on the basis of the decision, or because children raised awareness? It's impossible to say it's any one thing, but my own feeling from experience over the past 20 years of legal advocacy and work in this area is that it's a combination of all of these things. And so we shouldn't think of Opic as an end in itself. Rather, what we should think about is that it is a mechanism that's relevant as part of a broader strategy to generate change. And when we're thinking about that strategy to generate change, I think it's important to call for an early assessment of what your different options are, what their characteristics are, what in the context of the relevant issue, to see what might be most effective. Should we use the Opic individual communications procedure? Should we go for the inquiry procedure? Should we use Opic or another treaty body, such as the Committee on the Rights of Persons with Disabilities, the Committee on the Elimination of Discrimination Against Women? Should we go to a regional human rights mechanism rather than an international one? And the answer to all of those will depend on the specificities of the case or the situation, the characteristics of the mechanism, the limitations that they have, and also the goals and strategy that we've adopted, as well as the needs and the wishes of the victim survivors. We shouldn't forget that that is an important element. And we might find in developing that strategy that some mechanisms can complement each other. So it's quite possible to file a petition for an individual communication with the Committee on the Rights of the Child, while at the same time filing a communication to one of the UN special procedures, or filing a stakeholder submission under the Universal Peer Review. That can strengthen the advocacy. It might be that the timing of these things mean that one strengthens the other in a sequential way. We also need to remember that Opic might not be the answer. Opic might not be possible. The exhaustion of domestic remedies might prevent us from filing an individual communication, or we might find that the threshold of grave or systematic violations isn't met in the context of the inquiry process. And then the final reflection is, what if Opic isn't even a factor yet? What if the state party hasn't ratified Opic? And here what I would encourage you to think about is Opic ratification as part of a campaign for remedies and social change. And this reflects on something that Professor Skelton said, and one of the philosophies that we take in the context of effective and strategic use of the Opic. Because for us, recourse to Opic should only be a last resort. What we should be aiming for is the adoption in national law of child-sensitive and child-appropriate measures that allow for effective remedies for child victims of human rights violations at the national level. And Opic can drive that, but actually, even without Opic, it's the UN Convention on the Rights of the Child and the first optional protocols that should drive that, because there is an obligation to provide effective remedies for the very reasons that Anne pointed out in General Comment 5 as the foundation base. There is no right, or rights are illusory unless there are effective remedies. And if we're looking at effective remedies in the context of child victims of human rights violations, we must think of those as being child sensitive and child safe. Thank you very much.
Thank you very much, Alex, for this very important contribution to the conversation, highlighting basically the significance of Opic as part of the package, if I may use your wording. And I think you convincingly explained to us what that means, and that we can really benefit from having the instrument, at least in those countries that have already ratified, but that we have to have a broader strategy, which also includes a focus on domestic remedies. And that was also one of the points that Anne made in the very beginning of her contribution. So thank you very much for that beautiful circle. But if I may ask a question to Anne, and I would like to encourage all the participants to bring forward your questions, which we will then use also in our conversation with Anne and with Alex. I would like to go back to Anne first, if I may, to ask Anne about how the committee approaches the determination of the remedies. You were very clear in explaining that there is the individual level and the more systemic level, and you also showed us that there is this development of a very cautious beginning, where individual remedies were not even included, and then the more systemic ones were more open and maybe too undefined. But now we are in a different game with the final case that came out against France, with very specific guidance on what France should actually do. How proactive is the committee here is it the committee defining these remedies, or is it brought to you by the representatives of the children or by the children themselves even, or is it a combination? And what would then be your piece of advice or your advice to the legal practitioners in the room here, or the civil society organizations that support children or others in bringing these kind of cases? What would be your advice there? But maybe the first question is, how proactive is the committee here?
Actually, I think the committee is very proactive. And what I've seen so far, the authors tend to focus on the individual remedy when they're afraid. So they're pretty clear about what they want for the individual, but they tend to focus less on the systemic remedies. And so particularly when it comes to the systemic aspect of the remedy, the committee plays an important role in determining and shaping that remedy. And the committee has very active discussions on the remedy aspects. It doesn't just flow. It actually, you know, is something that we engage with, and we say, how far should we go? Like you'll notice in the French case, it says that the French government must act in good faith to return, to repatriate the children. And those words are there because in their arguments, the French government said that even if they could be held liable and asked to do something, they could only be asked to do something in good faith. So, so taking them at their word, we decided to build that in because, of course, it recognizes the fact that they're not entirely in control of everything that's going on in northeast Syria, even, you know, and in fact, that's Kurdish territory. No one's really completely in control. And so, you know, there are practical factors that have to be faced in the task ahead. But the fact is that the government, that now France will have to show that it made these good faith efforts. And I think that's important. And of course, we hope that will mean every child will come home and as soon as possible. But we realize that there could be other factors that intervene. So that, I think, shows how, you know, how much thought goes into those remedies, and trying to also create balance, also to think about the practicalities on the ground.
Thank you, Anne. And your advice to legal professionals, maybe civil society, on how can they guide you?
I think it's really important to be as creative as possible in coming up with remedies. And I speak here more with my litigator's hat on, my South African litigation experience, where I think that there we've made great strides in terms of remedy through very creative arguments by counsel. So counsel can come forward with suggestions on how a remedy can be structured, to be flexible, to have mechanisms at the national level, for example. You know, that's something that people on the ground would be better to work out. If there's a problem that needs to be resolved at the national level, how should that be resolved? And, you know, when it comes to compensation and claims sounding in money, my feeling is those are not good. Those are not being well implemented on the ground. And maybe we need to think about better mechanisms for how do we get that to, because it seems as though states are sitting back and saying, well, the committee said there should be compensation, but we don't have to do anything proactive about that. You know, the author can bring a case at the national level and then we will see. But how could we then, I'm thinking about that, how could we structure it so that it actually doesn't just get left up to only if the author, but that the state must take proactive measures. But perhaps, you know, council can help us by thinking about what that would look like at the national level, because they are closer to the systems and understand better how the systems could respond.
Thank you, Anne. Thank you very much. Nico, anything, any questions?
Yes, thank you, Tan. And going back to Alex's presentation, I think it was quite interesting in the sense of, well, in two different senses. First, the broader use of the different mechanisms that are part of this Opt 3, despite the inquiry procedure, and also this broader vision of the fact that there are no like superheroes. There's no one great superhero in these procedures. It's more like thinking about the different roles, and they all have an importance. The committee, the litigators, the advocacy, the government, and having that full picture is important when you are designing a strategy. I think that's really interesting. And regarding this case of Chile that you mentioned, I think this is a good example because that case is originally presented by a deputy, an opposition deputy of the government. So the motivations were not about having a better comprehensive system. Who knows what the motivation was, but actually the committee took control of this process, and it got richer through dialogue, and then the government takes that opportunity, and from that they were able to develop a comprehensive response. And this tells a lot about the dynamic stakeholders. And in that in particular, I'd like to ask Alex, could you expand a little bit more about their role? First of all, what's your opinion so far about the role that civil society has had in the implementation process of OP3? And I don't know if you have an appreciation about that. Do you think it has been used cautiously, or is there a comprehensive strategy for using the protocol? I'd like to know your analysis about the use of this protocol by the civil society. And I don't know if you think there's a particular aspect, because we are here with audience from different areas like civil society. So perhaps they could consider a particular factor so they can start using this protocol.
Thanks, Nicolás. Yeah, I think that in short, my answer is that yes, civil society does have a very important role in the implementation process. But in reality, there are two factors. One is that we still have only 48 states that are party to the optional protocol. And so the individual communications process is limited to them. And the second factor is that because of the relative youth of this instrument, there is still a lack of awareness and even a lack of understanding by all stakeholders, including civil society, about Opic and how it can be used, what can be done with it. So there is a very big potential, but it's at the moment untapped because at some levels it's not available, but also it's just not known. But what we have started to focus on with some of our partners, and we did this in the context of Palestine, was to really think about Opic in the context of follow-up to concluding observations, and almost flipping it from the other side, because it can feed in both ways. We can look at Opic cases being generated from concluding observations where the committee has already identified that there are areas of concern in the legislation, policy or practice of the state, and building cases around those. And from another perspective, think about how the views of Opic can be used in the subsequent reporting cycle. But I would say that that's not limited just to reporting cycle to the Committee on the Rights of the Child. Think more broadly as a civil society about how it might be relevant also to the Committee Against Torture. This was quite relevant in the context of the Chile inquiry and how some implementing measures were followed up. Think about how an Opic decision might be relevant to a universal periodic review report to the committee, at the UN Human Rights Council, where the advantage of that process is that if you have a state making that recommendation to pick up a particular Opic recommendation, then the state in question is confronted with a public decision on whether or not it accepts or rejects that recommendation. So you're really putting the state on the spot. Do I accept that I have to live up to what the Committee on the Rights of the Child has said, both in terms of the individual remedies or the systemic remedies, or do I look like a pariah and reject this recommendation? So it can be very powerful. So I've seen it used well. We think there's enormous potential for it to be used well, but there is a lot of work to be done.
Thank you, Alex, for that reflection. I think this is very helpful also to our participants. And how the committee actually could approach and could support also states in organizing themselves better in terms of providing domestic remedies. And of course, there's different ways of doing that, through concluding observations, through general comments, maybe a day of general discussion. Any thoughts on that, either as a member of the committee or in your private capacity as a professor? But I mean, I imagine that the committee has a big role to play there to offer some more guidance, also based on the experience.
Something that Alex mentioned was this informal meeting with states, which was actually the opportunity to have a conversation with them, in which we talk about the developments and how things are going. And, you know, in a way, we try not to scare them off too much at that point, but we encourage, we're always, because it's attended not only by states that have ratified, but also by states that haven't. So we do take it as an opportunity to try and encourage states to ratify. But we also point out, you know, where there have been gains, where there have been successes, to try and encourage states to feel like this is something positive that is happening and is being done. Perhaps there we don't drill down too much into the detail, but I don't see why we shouldn't. I mean, it's something that we could do as an advance in the future, perhaps, is to think about themes when we have those, you know, just assessing particular themes in those annual meetings. I can tell you that when it comes to Spain, the committee has had several meetings just with Spain to talk about follow-up. So the committee can and does, you know, engage with states, particularly when, you know, as with Spain, we have so many cases and there's so much catching up to do. So we do keep a dialogue going there. And the committee does ask states that, you know, for example, when Chile came to the committee, the fact that there'd been an inquiry was definitely in the mix of the dialogue. One sees that the Human Rights Committee does that a lot as well. They follow up in a way, use the dialogue process. So there's a kind of a, you know, the country, the state knows it's going to have to face that when it comes. So there's perhaps more that can be done. But I think that we can maximize on the opportunities that we already have, perhaps, rather than trying to think about something new because of the fact that, you know, there's so many meetings, so many commitments. But I think the committee can just make a stronger link between its Opic work and its reviewing work. And that in itself would be very helpful to hold states accountable and to remind them that this is part of a holistic picture on children's rights implementation.
Thank you so much, Anne. With that, I'm afraid we have to close this very enriching webinar. Thank you so much, Anne, Alex, for the very insightful presentations, very clear presentations. You took us really into the world of remedies, and we learned a lot. And I think there is also a big incentive to have our eyes more on the impact of Opic, as well as its connection to all the other activities that could be brought under this umbrella of Alex's package to secure sustainable systemic change. It was an absolute pleasure to have you with us, and on behalf of the Center for Constitutional Studies, but also Leiden Law School and the Leiden Children's Rights Observatory, I would like to thank you both and everyone else in the room for joining us. We have included some links to the new website of the committee, to the work of Child Rights Connect, and we will also include the website of the Leiden Children's Rights Observatory, and hopefully that will also help all the participants to find their way into this world of remedies. Thank you so much again, and we will look forward to seeing you again in a month or so for our 6th webinar. Thank you again.